hiyo face inanipamba hivi. Itakuwa nini yake, si ndio? Hebu nitaita. Sijua leo tukitoka ndani nini nione. Wakamuamulikishe fans. Wakamuamulikishe fans. Utaenda tu errands. Lakini nini fans nini kuna mko wengi like guy. Para kuingia kanisa ingia. Hata tukishindo bado tunaenda tunapanda hizo gari bado ziko YouTube. Sasa wewe mimi nishachoka kukaa huko ndani. Bado hata gari hata kupanda sisi nifanye face reveal. Labda wa face reveal yangu nata. Asante na kwenye. Ingia live. Mimi ndo nilifanya zote. Hey guys, mimi ndio manager yote. Ai. Lakini simu yako inapiga video kama zao. Video za simu yako na zangu ni the same. Yangu ni poa.
Sema aje sasa. Simu yangu ione. Mwambie sasa kweli. Yako ni yako 11 Pro Max. Unajua tutamwambia ati hey Kami. Tuko na mama.
Can you lift me up you? Wait. Nataka wanino ground.
Siwezi kuonyesha no. Mimi ndo na managing pia hii.
This is shoe game, the official game.
Wala,
by the way.
Wala, ile gari.
Lakini guza interior kidogo.
Acha nifungue.
Nani baba?
Nimesema ni sio madogo.
Mugande. Huyo mwambie aenda kuchegia kwa hapo. Huyo andika. Uzuri futa mwambie bora kila nangane uongo. Ukweli uongo. Ukweli uongo. Ukweli uongo. Sema ni kitu. Hiyo ground leo.
That be like.
Ninalala kama panga leo.
Lie to yourself.
No. Umekuwa sana wewe.
Sasa ulipendini ile yangu.
Usikiri kufa.
Nilikufa aje?
Nilikuja kunini content na au simu ikaikufa na ikakufa hivi. Nimeinua hivi ni record nini? Niliinua ni record baba yangu simu ikazima hivi. Peleka kwa fundi ananiambia sijui ni betri, ikaekwa betri mpya. Ananiambia sijui ni manga. Akaniambia ifrashiwe, ikafrashiwa. Nilifika mahali hesabu za amenifanyia ile pesa yote nafaa nitoe. Hizo amenipigia hesabu ya betri ni 4,000, amenifrashia na 2,000. Hizo ni sita. Na bado anafaa sijui vitu zingine. Nilimwangalia hivi nikasema, fundi wewe sikuwahi rudi. Kwa nini nimeenda nikinunua hivi?
Ba? Mchongo na drink kwa. Ndio
Nipeleke kwa mekaniko ndani.
Kwa ni kema wewe.
Si kitu yaanze.
Sio nani alikuwa Kabrosa alikuwa. Kabrosa alikuwa nini? Sio ndio mmoja alikuwa. Sio hiyo sipo Kabrosa. Unakwambia hiyo nayo sisi kubali. Utasikia mwenyewe. Ujamaa huyu. Lakini hata wewe hapo tunaruhusu wewe uko.
Na mkono masimu huko na mkono masimu
huko watu wako na manini gadgets.
nani
Fantas.
nani wala simulikisha
Usimulikishe. Kwani hafai kuitwa hivyo? Anakaa unajua tulikuwa tumeambiwa vibao ama wewe mwenye umesomea nini? Vibao ama nikianza kubao pale nianguke. Unajua sasa tunaweza inama tu iname for life.
Silence in the court uongo sio.
ulikuja na syndicate nilikuwa hapa na siku hiyo
kwa shule yako na
Faida alisema yako
kwa practical
ni ya nini kama kwa culture the eyes have it.
Unaonaje kuhusu Stinger? Stinger. Hiyo spoiler aliweka.
Kama amebeba filimbi.
Lakini ile gari wajaribu
Stinger.
unasema Stinger na Spice.
Spice ni tamu. Kwanza ukiangalia hii Stinger wangeinua vile wameinua.
Ni sawa, nimemaliza. Mwenye alikuwa na Kenya simu nimemaliza kutumia.
Yaani group yake
Gram.
Inatoka lini na iko wapi tuiende?
Nilikuwa nasikia iko Ngara.
Nini iko Ngara?
Stima.
Thank you. Who's in this one?
Good morning, my brother. I'm Nandana holding this for Mr. Mogoi for the petition.
Yes. The matter, my name is Stephen. You have the 24 testimony.
Your Lordship, may please you.
Yes.
My name is Weche. I appear for the first to the third respondents.
Mr. Weche for the first, second, and third respondents.
The judgment is ready. I will not read it in full. It will be uploaded after delivery. The totality of the foregoing leads me to the conclusion that the petitioners did not discharge the burden of proving that the respondents violated their constitutional rights and fundamental freedoms in the manner pleaded, nor did they prove on evidence the essential ingredients that would sustain the government of their case as framed around malicious prosecution. Conclusion on orders for the reasons set out above. The amended petition dated 17th February 2025 is not merited and is dismissed. Each party to bear its own costs. Orders accordingly, file closed accordingly. It is signed and delivered virtually on this 19th day of February 2026.
To oblige your Lordship, thank you.
So you can check tomorrow morning for the CTS uploaded. Thank you, Council. Have a good day to you.
Good day, my Lord.
Thank you.
Petition E283 of 2025. Alghanja, legislative office in the Republic.
Thank you. Who's in this matter?
Madam President, I will ask for the second respondent.
Committee prisoner?
Good morning, my lord.
Good morning.
Yes, actually, I'm going to express before court.
Mr. Agri Amune, petitioner in person. Habari ya asubuhi bwana Amune. Uko salama? Nitasoma uamuzi wangu katika lugha ya Kimombo. Alafu kama hutakuwa umeielewa, utaweza kuelezea kwa kifupi katika lugha ya Kiswahili. So I'll begin at paragraph 23. Applying those standards, this petition does not meet the threshold. The petition cites numerous constitutional provisions, but the factual narrative is confined largely to conviction, appeal dismissal, and time served, with cursory assertions that rights were violated. It does not identify what specific act or omission by the Attorney General or the Director of Public Prosecutions violated which right and in what manner. This petition arises from a criminal trial and a criminal appeal. The petitioner confirms that the appeal challenged conviction and sentence, and it was dismissed. The petition then asked this court to do outcome by remitting for an appropriate remedy or sentence and by ordering liberty. The petitioner seeks a second judicial
bite at a sentencing challenge without demonstrating the kind of exceptional circumstances that would justify reopening through a properly framed and procedurally compliant sentencing application. The combination of a concluded appeal and a new constitutional petition seeking sentencing relief on the same sentence presents features of forum shopping that the doctrines of res judicata and abuse of process are designed to restrain. For the reasons set out above, the court makes the following orders. The petition dated 31st March 2025 is dismissed. There shall be no orders as to costs. Orders accordingly, file closed accordingly. Dated, signed, and delivered eventually this 19th day of February 2025. Bwana Agri, umenielewa ama ungependa nikuelezee kwa kifupi katika lugha ya Kiswahili? So katika uamuzi wangu nimesema kuwa kwa sababu ulikuwa umeenda katika mahakama ambayo iko juu ya mahakama yangu, yani mahakama ya rufaa, na walisikiliza yale yote ambayo umesema katika hii petition, sina uwezo wa kufungua na kuangalia kama uamuzi wao ilikuwa halali ama haikuwa halali. Mahakama ya rufaa ni mahakama juu yangu. Umeelewa? Lakini tutaweka katika mtandao wa CTS na pia tutatuma katika kamati maximum kwa kutumia barua pepe uamuzi huu, na utaweza kusoma na pia kujadiliana na paralegal na watakwambia vile unaweza kufanya kama kuna chochote cha kufanya. Umeelewa? Asante sana, uwe na siku njema. Mr. Mulati, have a good day.
You too, thank you, my lord.
The court affirms drink. Court reads and signs, and it also doesn't happen. Court reads and signs the judgment dismissing the petition with no orders as to costs, file closed accordingly. Now for another. Next, please.
Petition E747 of 2025, Inuka Kenya, Misisi, Transparency International Kenya, and two others, versus the Privatization Commission and others.
Thank you. Who's in this one?
Me? Please, my lord, my name is Yaka, presenting the petitioners.
Thank you. Respondents?
My lord, I'm Kaumba. I appear for the first, third, and fourth.
First, third, and fourth respondents. We ordinarily have Ms. Ngani for the second respondent. Anyone for the second respondent?
I'm present, Your Lordship.
Ms. Ngani for the second respondent. Thank you. Interested parties? Any interested parties? No appearance for the interested parties. So there are three matters on privatization. I will read them separately. You will also have a media summary immediately after delivery of the third one. So you have three media summaries, one for each. And the CTS uploads will be done shortly thereafter. In this matter, this one is 747 of 2025. You have a fairly long judgment. I will read from paragraphs 130 onwards, which is determinative. Paragraph 130. In the absence of any established constitutional violation, the relief sought, including declarations of unconstitutionality, mandatory injunctions, and structural interdicts, cannot be granted. Constitutional remedies are not granted as a matter of course. They depend on a demonstrated infringement of constitutional rights and principles. The petitioners have failed to discharge this burden. This court is acutely conscious of the profound public interest that attaches to the privatization of state-owned enterprises. Such assets are not the property of any government, administration, or political party. They constitute the sovereign wealth of the Republic of Kenya, held in trust for the people of Kenya, both current and future generations. Their disposal must be seen to be conducted with the highest standards of integrity, transparency, and accountability. The Privatization Act 2025, when measured against the exacting standards of the Constitution, fully satisfies those requirements. It is the product of a legislative process that faithfully observed the constitutional mandate of public participation and heeded the judicial guidance of this court. That is a reference to the previous matter handled by Judge Onita J. The Act establishes a framework that not only preserves but strengthens the oversight role of Parliament. It subjects executive discretion to clear, judicially reviewable criteria and its procedures that are both competitive and transparent, and directs all proceeds into the consolidated fund, where they remain fully accountable to constitutional appropriation and audit. This judgment should not be read as an endorsement of privatization as an economic policy. That is not the court's rule. The wisdom or folly of privatization is a question for the political branches, the executive, which proposes policy, and the legislature, which approves it. The court's role is limited to, but constitutionally vital, ensuring that whatever policy is chosen is implemented through lawful means and within constitutional limits. The Privatization Act 2025 survives that scrutiny. The petition is dismissed. In exercise of this court's discretion under Section 27 of the Civil Procedure Act and the principle that courts follow the event, but mindful that this is public interest litigation brought in good faith by organizations dedicated to constitutionalism, each party shall bear its own costs. Accordingly, for the reasons set out above, this court makes the following orders. The petitioners challenge the Privatization Act 2025 based on the alleged violation of the doctrine of separation of powers, the alleged undermining of parliamentary oversight insofar as it relates to the Cabinet Secretary's identification function, the alleged violation of Article 27, equality and freedom from discrimination, and the alleged violation of Article 43, socio-economic rights, are barred by the doctrine of res judicata and are hereby struck out. The public participation conducted by the National Assembly prior to the enactment of the Privatization Act 2025 is hereby declared to have been reasonable, meaningful, and constitutionally sufficient, and in full compliance with Articles 10 and 118 of the Constitution. C. The Privatization Act 2025 is hereby declared to be constitutional and valid in entirety. None of the provisions impugned by the petitioners, specifically Sections 7, 21, 22, 23, 31, 32, 34, D, 35, 36, 37, 38, 39, 43, subsection 2, 45, 54, 55, 65, 67, and 71 are inconsistent with the Constitution of Kenya 2022. E. The Privatization Act 2025 contains adequate systems of checks and balances to protect the sovereign assets of the people of Kenya. E. The structure of the Privatization Authority as established under the Act is constitutional. The appointment of its members by the Executive does not violate Articles 10, 73, or 232 of the Constitution. F. Sections 22, 31, and 67 of the Act do not constitute an unconstitutional delegation of legislative authority. The Cabinet Secretary's discretion under these provisions is structured, criteria bound, and subject to judicial review and parliamentary oversight. G. The prayer for mandatory injunction compelling the National Assembly to publish the departmental committee report is declined. The said report having already been published and being in the public domain. H. A declaration is hereby issued that all proceeds from privatization must be deposited into the consolidated fund and managed in accordance with the Public Finance Management Act 2012 and Articles 201 and 206 of the Constitution. The Privatization Act 2025 by Section 54 already so provides. The prayer for mandatory injunction compelling the involvement of the Auditor General in valuation and due diligence is declined. The Auditor General's constitutional mandate under Article 29 is to audit the application of public funds post-expenditure, not to conduct pre-transaction commercial valuation. J. The petition dated 13th November 2025 is hereby dismissed in its entirety. Each party shall bear its own costs, orders accordingly, file closed accordingly. Dated, signed, and delivered virtually this 19th day of February 2026. So court reads and signs the judgment dated 19th February 2026, dismissing the petition, each party to bear their own costs, file closed accordingly. So thank you, Council. Next, please.
Petition E714 of 2025, Edith Karanga Matindi, the State Law Office, Phoenix, and others.
Thank you. Who is in this one?
Good morning, Your Lordship.
Good morning.
It's Edith Matindi here. The petitioner is E714 of 2025, appearing in person.
Thank you, and good morning.
Good morning to you, sir.
The clerk of this house, please.
I do apologize.
The respondents are the National Assembly, the Senate, and the Honorable Attorney General. Anyone for the respondent?
Your Lordship, Ms. Ngani for the first respondent.
Ms. Ngani for the first respondent.
Kaumba for the third.
Kaumba for the third respondent. No appearance for the second respondent, being the Senate. I will read from the determinative last few paragraphs. The CTS after will be done shortly after this, and there will also be a media summary that will be released immediately after delivery. In conclusion, the petitioner's constitutional challenge to the Privatization Act 2025 fails in its entirety as outlined below. A. The challenge to the enactment process premised on the exclusion of the Senate is barred by the doctrine of res judicata. Specifically, issue estoppel. In any event, that challenge is without substantive merit, as the Privatization Act 2025 is not a bill concerning county governments within the meaning of Article 110 of the Constitution, and alternatively, it was properly enacted as a money bill in accordance with Article 114. B. The substantive challenges in sections 6, subsection B, sections 32, 54, 55, together with the third schedule, and 65 of the Act are unfounded. The petitioner has not discharged the burden of proving unconstitutionality. Each provision falls squarely within the competence of the legislature and reflects a rational policy choice for the governance of privatization. The Act incorporates adequate procedural safeguards and operates in conformity with the overarching principles and values enshrined in the Constitution, including Articles 10, 34, 35, 65, 110, 114, and 206. Accordingly, for the reasons stated above, this court makes the following orders. The notice of motion dated 31st October 2025 and the petition dated 31st October 2025 are hereby dismissed in their entirety. 2. The Privatization Act 2025 is declared to be constitutional and valid. 3. Each party shall bear its own costs. Orders accordingly, file closed accordingly. Dated, signed, and delivered virtually this 19th day of February 2026.
Most obliged, Your Lordship. Thank you very much. Good day, everybody.
Good day. I've made a mistake. 19th reads and signs the judgment dated 19 February 2026, dismissing the application subsumed into the petition, as well as the petition. Each party bears on costs filed first accordingly. Next, please.
Petition E517 of 2025, Consumer Federation of Kenya and others, by the Cabinet Secretary, National Treasury and Economic Planning and others.
Good morning, Your Honor.
Good morning.
In that matter, my name is Mulongo Haron. I appear alongside Tali Israel Tali for the first petition.
Okay. Anyone else in this matter? Any other petitioners?
My Lord. So, my Lord, the matter, my name is Mbaya for the first petition.
Mr. Mbaya for the first respondent. Anyone else in this matter? Yes.
I appear for the second, third, and fifth respondents.
Second, third, and fifth respondent. Ms. Ngani, you're for the fourth?
Yes, I appear for the fourth respondent.
Ms. Ngani for the fourth respondent. Interested parties?
Good morning, my Lord.
Good morning.
Founder for the second interested party.
Ms. Kaunda for the second IP, the Securities Exchange. Anyone else?
Good morning, my Lord. Yes, good morning, my Lord. I'm Ms. Mahla for the third interested party.
Ms. Maina for the third interested party, Competition Authority of Kenya.
Yes, my Lord.
Any other parties? Any other petitioner other than the first petitioner? Any other interested parties? I'll begin, it's a very long judgment. I'll begin reading from paragraph 161. Those are determinative. This court finds that the involvement of the National Land Commission is not required at the parliamentary approval stage of the privatization process. The transfer of shares in a state corporation does not constitute the alienation of public land. The valuation of KPC's land assets will be undertaken at the implementation stage under the oversight mechanisms provided in the Privatization Act. Should any actual disposition or alienation of land occur, the National Land Commission will have a role in accordance with Article 67, Clause 2 of the Constitution. At this juncture, no such disposition has taken place, and the petitioner's concerns are therefore premature. Accordingly, this ground of challenge fails. Conclusion. Having carefully considered the consolidated petitions, the responses thereto, the written submissions, and the authorities cited, this court makes the following findings. A. On jurisdiction, this court has full and undoubted jurisdiction to determine the consolidated petitions. The petitions raise pure constitutional questions regarding the validity of the proposed privatization of Kenya Pipeline Company Limited. The doctrines of exhaustion, ripeness, and constitutional avoidance do not apply to oust this court's jurisdiction. B. On the reliance of the 2008 cabinet approval, while the original approval alone cannot sustain the constitutional validity of the process in 2025, the subsequent steps taken, including the 2025 cabinet approval of the specific proposal and the extensive parliamentary process, have infused the process with sufficient contemporary constitutional consideration to address this foundational concern. C. On public participation, the process conducted by the National Assembly in respect of sessional paper number 2 of 2025 was meaningful within the framework established by the Supreme Court in British American Tobacco Kenya PLC, SUPRA. The Joint Committee received 40 memoranda from members of the public, heard 10 stakeholder groups, including the second petitioner, and produced a comprehensive report addressing the issues raised. The second petitioner was given and took the opportunity to present its views, which were considered by the committee. D. On public finance, the respondents have taken reasonable steps to comply with the principles of public finance under Articles 201 and 227. The process has been informed by comprehensive due diligence, including financial analysis. The valuation will be undertaken by qualified persons at the implementation stage. The proceeds will be subject to parliamentary appropriation, oversight by the control of budget, and audit by the Auditor General. E. On national security and consumer protection, the petitioners have failed to demonstrate any violation of constitutional obligation. The regulatory framework governing the petroleum sector remains intact and will continue to protect consumers and safeguard national security interests, regardless of changes in corporate shareholding. F. On employees' rights to fair labor practices, this court lacks jurisdiction to determine employment-related grievances raised by the second petitioner. Those grievances may properly be pursued before the Employment and Labor Relations Court. The respondents have demonstrated that they have taken steps to address employee concerns and to ensure the employees are not disadvantaged by the privatization process. On the role of the Competition Authority, the authority did not abdicate its statutory or constitutional mandate. The acquisition of Kenya Petroleum Refineries Limited by Kenya Pipeline Company Limited was properly assessed and found not to constitute a notifiable merger. The privatization of the first interested party is not at a stage where a merger notification is required. H. On the disposition of public land, the involvement of the National Land Commission is not required at the parliamentary approval stage. The transfer of shares in a state corporation is not the alienation of public land. The valuation of the company's land assets will be undertaken at the implementation stage and will be subject to the oversight mechanisms provided in the Privatization Act. In the result, the consolidated petitions fail. The proposed privatization of Kenya Pipeline Company Limited has been conducted in substantial compliance with the Constitution and the law. The process has been transparent, has involved meaningful public participation, and has taken into account the legitimate concerns of stakeholders. The court makes the following orders. A. The consolidated petitions dated 14th August 2025, 25th August 2025, and the amended petition dated 4th September 2025 are hereby dismissed. For the avoidance of doubt, proposed privatization of Kenya Pipeline Company Limited, as set out in sessional paper number 2 of 2025, is not unconstitutional and will proceed in accordance with the Privatization Act 2025, so a typo there, 2025, and subject to the observations and recommendations contained in the report of the Joint Committee on Energy and the Select Committee on Public Debt and Privatization dated 14th August 2025. C. The second petitioner, the Kenya Petroleum and Oil Workers Union, is at liberty to pursue any employment-related grievances arising from the implementation of the privatization before the Employment and Labor Relations Court. Each party shall bear its own cost, this matter being public interest litigation. Orders accordingly filed. Dated, signed, and delivered virtually is 19th day of February 2027.
Your Honor, most obliged, when can we be able to receive a copy of the judgment?
We are releasing the media summary immediately after this memo. The judgment, I've noticed some typos like 2005, not 2025. Let me have a read through this afternoon of all three, and then we can release them in the morning.
Okay, much obliged, Your Honor.
My Lord, in the information,
yes, please.
have you placed me in record for the second petitioner?
Yes.
Otokoma?
Ms. Otokoma.
Yes, my Lord.
Holding brief.
Holding brief for Mr. Onyoni for the second petitioner.
Mr. Onyoni for the second petition. So court finds the judgment dated 19 February 2026, dismissing.
Into your.
So just a moment, I need to confirm with my colleague. Next, please.
Petition E001 of 2026, Okiom Total Creative and the National Executive, Attorney General, and others.
Thank you. Is in this matter? Who's in this matter?
Your Honor, Michelle?
Yes.
Say your petition.
Mr. Bernard Sherry, the second petitioner in person. Thank you. Anyone else?
My Lord, the matter, my name is Mbaya.
Mr. Kaumba?
Here for the first.
Anyone else?
And my Lord, my name is Okiom Total Creative.
So that's with the first interested party and Mr. Okia Ontata Okoiti, the first petitioner in person. Good morning to both of you. Anyone else in this matter? So this matter is coming up for a ruling on certification. As I have just delivered the 3 judgments in the other matters, and given what I have concluded, it would not be judicially safe for me to continue having conduct of this matter. So I will then disqualify myself from this matter for those reasons, and I will give you a mention before my brother Judge Mugambi J. 2nd of March, is that convenient for all of you? Anyone who can court, this judge having delivered 3 judgments this morning on various aspects of privatization in Kenya, the Privatization Act 2025, and the actions of various respondents herein, and having done so as a single judge, it would not be judicially safe for this judge to have conduct and to deliver a ruling on certification, or to otherwise hear and determine aspects of this matter. Consequently, I disqualify myself from conduct of petition E001 of 2026 herein, with my last order of business in this file being merely the administrative step of placing this file before Mugambi J the other judge in the division. So mention before Mugambi J on 2nd of March 2026. So that will give parties sufficient time to, one, peruse the 3 judgments that I've delivered, and secondly, to allow my brother to bring himself up to speed with this file. My apologies to parties and to counsel. It only became apparent to me that I would have to say some, have to address some issues as I was writing those judgments, so it was not apparent right at the beginning. My apologies for the inconvenience that has caused yourselves. So with those apologies, thank you parties, thank you counsel, have a good day.
And to find the time out, kind of your permission.
Yes, please.
Kind of your permission, my lord.
Yes, please.
Yeah, we were given the date of 19, in view of the fact that the IPO was taking on a momentous stand today.
Yes.
And we requested for some mechanism for preserving the motion.
Yes.
And by 3rd of March, a lot of ground would have shifted.
Yes.
I was praying that maybe you give us some way of preserving this petition, even as we go to...
Yes. I appreciate what you're saying, and yes, I appreciate what you're saying, Mr. Omtata. Having assigned, rather disqualified myself, and then automatically this file now is for Mugambi J. Any applications, oral or in writing, will be heard and determined by my brother Mugambi J. So if you wish to...
I understood you, madam, I just finished.
Yes.
So we're requesting administrative functions.
Yes.
If the file could be placed before the land judge today, for purposes of requesting that conduct of order.
Just give me a moment. Let me reach out to my brother. I see whether he's still in session. Thank you for your patience. Mr. Omtata, the court number 2, Mugambi J, is currently performing the functions of the presiding judge. We have a meeting that he's preparing for, so he's not sitting at the moment. If you're able to put that in terms of an application, that would be fine. I can give you a mention before him. We have a bench tomorrow, but I don't believe he'll be dealing with single judge matters. Could we try for Monday? That's the best we could do.
Not on that, my lord.
Okay.
Yes, my lord.
So notwithstanding the substantive mention on 2nd March 2026, a preliminary mention to address Mugambi J on conservatory orders is fixed for Monday, which is 3rd February 2026, at 9 a.m. virtually, typed proceedings of the last 3 appearances to be undertaken before then. So Mr. Omtata, and to the rest, you have 2 mentions, one for Monday and then a second one on 2nd of March 2026. But of course, my brother Mugambi J is at liberty to thereafter on Monday, in interfere with those timelines and bring them back or otherwise. Any other business before I pen off? Thank you. Have a good day.
Have a good day.
Good day. Please, just in case of the handwriting.
Yes.
Okay, thank you. Next, please.
Petition E335 of 2025, Metro Metropolitan and others with National Transport and Safety Authority and others.
Thank you. Who's in this matter?
Your Lordship, Outa, I do appear for the petitioner.
Your Lordship, next key number for the holding brief for Mr. Rai for the first and second respondents.
The number holding brief for Ms. Sirai for the first and second respondents. Thank you. Good morning.
Good morning.
We ordinarily have Mr. Weche. Yes.
Your Lordship, my name is Adambi. I appear for the sixth respondent, the National Assembly.
For the sixth respondent, good morning.
Good morning, Your Honor.
We ordinarily have Mr. Weche appearing for the third, fourth, and fifth. Thank you. Mr. Weche for the third, fourth, and fifth respondents. So with my profound apologies, I've not been able to complete this judgment. It is made some substantial progress, but it is not ready for delivery. Today, I'd like some more time. So the date that I have available for delivery is 29th of April. The court, with the court's apologies, this judgment is not ready, and the same shall be delivered on 29th April 2026 at 10:30 a.m. virtually. So with those apologies, thank you, counsel.
My Lord, we have noted the position. I was only requesting that the interim orders were issued to extend at the close of business of that date.
The interim orders have been confirmed and extended till the date of judgment. That is what I've recorded, so I'll just put that for the avoidance of doubt. For the avoidance of doubt, interim orders in force to apply and are extended to end of day 29 April 2026 unless otherwise varied, vacated, or made permanent. So once again, my apologies. Have a good day.
Thank you, Judge. Have a good day.
So with respect to the privatization matters, the media families have gone past.